All right, let's jump right in. Today, we're getting tactical. We're talking about how you, as a barrister, can shut down litigation that has no business being in court before it gets anywhere near a full, expensive trial. This is all about being sharp, being efficient, and saving your client a world of pain.
So picture the scene, because you're going to face this. Your opponent files a defense, and you're just looking at it, and it's full of holes. You can see it's just a tactic to drag things out. So are you stuck? Do you really have to go through the whole costly pre-trial dance for a judgment your client clearly deserves right now? The answer, thankfully, is absolutely not.
Yeah, this is the classic scenario, a baseless defense. The other side throws up a pleading that's clearly just meant to frustrate the whole process. It forces your client to gear up for a trial, spending time and money, even when you know the other side doesn't have a leg to stand on. We call this an unsustainable pleading, and your job is to terminate it fast. So how do you do it?
Well, the good news is you're not powerless. The rules of court actually give you an arsenal. And in that arsenal are two very specific, very powerful weapons you can use to bring things to a quick end. Knowing which weapon to pull out and when, now that is a critical skill for any barrister.
Okay, let's get into weapon number one. This is a big one, the application for summary judgment. Now, you need to understand this is your go-to when the problem isn't some technical flaw in how the defense is written. No, the problem is that there's just nothing behind it. It's an empty shell with no factual substance.
So what exactly is it? Think of summary judgment as a shortcut to the finish line. It's a judgment you get early based on affidavit evidence. The whole idea is that you go to the court and you say, look, the defendant's case is so factually weak they have no real prospect of winning this thing, so why on earth would we have a trial?
And here is the rule number you need to burn into your brain, especially for the Queensland Bar exam. Ready? UCPR Rule 292. When your brain sees a factually baseless defense, it needs to immediately fire back. Rule 292. This is your authority, this is your power. Let's say it one more time so it sticks. UCPR Rule 292.
Now, Rule 292 gives you a really clear two-part test. It's a hurdle with two bars you have to clear. First, you've got to show that the defense has no real prospect of success. And second, flowing from that, you have to show there is no need for a trial. You got to nail both of them to win.
That phrase, no real prospect, is really key here. You see, the courts, like in the Salcedo case, have made it clear this is a more liberal, easier test to meet than the old school standard, which was that a case had to be hopeless or bound to fail. That was a really high bar. Now you just have to show their prospect of success isn't real, it's merely fanciful. This makes summary judgment a much more accessible and potent weapon for you.
So remember, a Rule 292 application is all about the evidence. You put on your evidence in an affidavit showing the strength of your claim. Then, the burden shifts. It's on them. They have to come up with some actual evidence to show there's a real issue that needs to be decided at a trial. If they can't do it, they're in big, big trouble.
Okay, so let's lock that in. Summary judgment under Rule 292 is all about the evidence, and the question is whether there's a real prospect of success. Got it. But what happens when the problem isn't the evidence, but the pleading itself? What if the document is legally garbage? Well, for that, you need a different weapon.
And this brings us to weapon number 2, an application to strike out. This is a fundamentally different tool, aimed at a different target. You don't use this when a defense is factually empty. You use it when the pleading itself is legally defective right on its face.
And here it is, the second rule number you absolutely have to know, UCPR Rule 171. If summary judgment is 292, a defective pleading is 171. Think of them as a pair. Rule 171 is your authority to attack a pleading that is just fundamentally flawed in law.
Now, here's the core difference you have to grasp. For a strikeout application, the court ignores all the evidence. No affidavits, nothing. It looks only at the four corners of the pleading itself. The question is purely legal. Even if we assume every single thing alleged in this document is true, does it actually amount to a valid cause of action or a valid defense in law?
So Rule 171 gives you specific grounds. The big one is that the pleading fails to disclose a reasonable cause of action. But it could also be that it's scandalous or an abuse of the court's process. Or it could be frivolous or vexatious, which is really just lawyer speak for something that isn't serious, has no proper foundation, or is just designed to harass somebody. In short, it's plainly hopeless.
So we've covered the two main weapons for getting rid of a case early. Now let's boil this all down into your exam playbook. This is the tactical choice, distilled into a simple framework that you can take into your prep and into your practice.
Here it is, the whole tactical choice at a glance. Let's run through it. Summary judgment, that's Rule 292. The focus is evidence. The test is no real prospect of success. You use it when a case is factually baseless. Now, striking out, that's Rule 171. The focus is the pleading itself. The test is no reasonable cause of action, and you use it when a claim or defense is legally flawed. Memorize these distinctions. This table is the core of your tactical decision-making.
You know, knowing the rules is one thing, but being a barrister, a real advocate, is about judgment. It's about having the confidence and the courage to actually deploy these weapons effectively for your client. You've got the playbook now. So the only real question left is, when will you have the courage to use it?